Supreme Court Case Reynolds v. Sims, number 377 U.S. 533, court date June 15, 1964. This was a United States Supreme Court case that ruled that state legislature districts had to be roughly equal in population. Voters from Jefferson County, Alabama, had challenged the apportionment of Alabama legislature. The Alabama Constitution provided that there be at least one representative per county and as many senatorial districts as there were senators. Ratio varied as greatly as 41-1 from one senatorial district to another. Having already overturned its ruling, that redistricting was a purely political question in the Supreme Court case Baker v. Carr. The court went further in order to correct what seemed to it to be a flagrant example of malapportionment, which were serious enough to undermine the premises underlying Republican government. Before Reynolds, urban counties were often drastically underrepresented. The 8 justices who struck down state Senate inequality based their decision on the principle of one person, one vote. In this majority decision, Chief Justice Earl Warren stated that legislatures represent people, not trees or acres. Legislatures are elected by voters, not farms or cities or economic interests. Justice Potter Stewart issued a concurrence dissent in which he argued that while many of the schemes of representation before the court in the case were flagrant, undemocratic, and clearly violative of equal protection, it is not for the court to provide any guideline beyond general reason for apportionment of districts. Stewart voted against the majority in the Colorado and New York cases. Although Justice Tom C. Clark joined his concurrence dissent, Clark did not join Stewart in voting differently in the Colorado and New York cases. In dissent, Justice John Marshall Harlan II attacked the court for ignoring the original intention of the Equal Protection Clause, which he argued did not extend voting rights. Harlan claimed the court was imposing its own idea of good government on the states, stifling creativity and violating federalism. Although the Constitution explicitly grants 2 senators per state, regardless of population, Harlan further claimed that if Reynolds was correct, then the United States Constitution's own provision for 2 United States senators from each state would then be constitutionally suspect, as the 50 states have anything but substantially equal populations. You heard me a second ago mention the Equal Protection Clause. Well, what is the Equal Protection Clause? It's found in the 14th Amendment. If you look in the first section, the second sentence, you will see it start by saying, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of its laws." The Equal Protection Clause can be seen as an attempt to secure the promise of the United States' professed commitment to the proposition that all men are created equal, by empowering the judiciary to enforce that principle against the states. As written, it applies only to the state governments, but it has since been interpreted to apply to the federal government of the United States as well. Let's look at Earl Warren's words once again. Legislators represent people, not trees or acres. Legislators are elected by voters, not farms or cities or economic interest. What Earl Warren was getting at was that people elect legislators. The legislature, the House of Representatives, represents people and nothing more. In 1964, cities like Memphis Chicago, New York, all of these places had been becoming heavily populated for quite some time now, but yet they don't have the proper representation in the legislature. After the Supreme Court justices had cast their votes, 8 votes were for Sims and 1 vote was against. The next day, in the New York Times, it states, the Chief Justice detailed the facts of the Alabama case. The districts in both houses of the state legislature had remained unchanged since 1901 and were sharply disparate in population. After a suit was filed, a special session of the legislature adopted 2 provisional reappointment plans to be effective in 1966. A 3-judge federal district court combined features of the 2 plans into temporary apportionment, which was used in the 1962 election. Both the plaintiff voters and the defendant state officials appealed. The argument was that the people of Alabama could no longer properly cast their vote because Alabama did not have proper population representation in the legislature. Representation being based on population maps. These maps and figures not being updated since the turn of the century, and this being 1964, representation was no longer done properly in Alabama. Of course, on the other side of the argument, you have people like William Buckley of the Delta Democrat Times, located in Cleveland, Mississippi, that agree that this is in violation of states' rights. He believed that states are supposed to be able to choose how they want to represent themselves in the legislature, when the federal government and the federal court agree that representation should be based on population. This case and other cases involving states like New York and Illinois were also in the Supreme Court around this time, and in 1966 a change was taken so that the legislature properly represents the nation based on population maps. Historically, there is no evidence at the time of the adoption of the 14th Amendment that the term equal protection applied to political questions, like how a government should allocate representatives. Indeed, the widespread use of representation based on geographic or political subdivision in the states granted each state 2 senators and at least 1 representative, regardless of population. The idea of our American government is that each person has an equal vote, an equal representation. And now that this court has ruled that the legislature should be represented based on population, now each person can have an equal vote regardless of where they live and their situation.